Hi everyone, welcome back. Hope you had a great lunch. So now we're moving on to the class observation portion of our day, and I'm happy to introduce Professor Amy Monahan to you. This is an employee benefits class, and so the current students are all in the front rows, and so listen, and you don't need to participate for those of you who are admitted students, but take it away. We'll be done here at about 2:15, and then we're going to move to Wiley Hall. So we'll have ambassadors here to direct you to where that is, okay?
Thank you. Well, thanks. Before we start class, because you're supposed to be observing a regular class, I do just want to take a minute to welcome you to the University of Minnesota Law School and congratulate you on your admissions. We're delighted to have you here, and I'm delighted to play a small role in your day. So before we dive in, I just want to tell you a little bit about this class. So this is an upper level elective course. It's employee benefits law. The students are all second and third year students. There are not any prerequisites for this class, so it's a pretty standard upper level elective. And what we're doing in this class is looking at how the law regulates employee benefits. So one way to think about that is non-cash compensation that employers give to employees. The two primary types of those are retirement plans and health plans. So we've got lots of work to do during the course of the semester looking at what the law has to say about employer-provided retirement plans and employer-provided health plans. And today what we're looking at is some of the ways that healthcare reform, the Affordable Care Act, changed how health plans are regulated, what employers have to do within that sphere. And of course, there's lots of interesting things going on there. One thing you'll note when you visit law schools, whether this one or others, is that you're going to see lots of different teaching styles. Just to sort of situate where I fall, I do not teach the class entirely based on the Socratic method, which is what most people are familiar with. We will have some Socratic dialogue to talk about cases, but given that this class focuses a lot on one particular federal statute, we spend time working through statutory language. I even lecture a fair amount, and we often have problems that are prepared in advance that we go over in class. So it's sort of a hybrid approach for this class. So we left off in our last class talking about the new requirements that the Affordable Care Act imposed on group health plans, on employer-provided plans. So we had just gone through the requirements that apply to all group health plans, and now we're going to shift and talk about what are the additional requirements that apply to non-grandfathered group health plans. That's a technical term that we defined yesterday. And most plans are going to fall into this non-grandfathered status because it's pretty hard to maintain grandfathered status, particularly over time. So what's the big deal? What do they have to comply with that grandfathered group health plans don't? The first, which is one we're going to talk about in a lot more detail in just a minute, is that plans have to cover anything labeled as a preventive service first dollar. And remember, that means the plan pays in full, no cost sharing can be imposed. And when we talk about Hobby Lobby in a minute, we'll see an example of how broad the definition of preventive health services is, right? This isn't just they have to pay for your annual physical. A very wide range of services counts as preventive. All the group health plans have to allow direct access to OBGYNs and pediatricians. This typically comes into play with respect to managed care plans that very often contain terms that if you go see any specialist, you have to get a referral. So a lot of plans were set up that way. So if you were a pregnant woman, for example, you would have to get your primary care physician to specifically refer you to an OB. Same thing with care of your children. That does away with this. No matter what type of plan you have to have direct access to those specialists. Anytime you receive emergency care, it has to be treated as in-network coverage. So we've talked about the fact that many plans have a preferred network of providers. Some even have closed networks that say we're only going to pay for coverage if you go to somewhere in our network. This says if you're having an emergency, you can go anywhere, and your plan can't deny you coverage because you went out of network or pay less because you went out of network. The Affordable Care Act also imposes maximum out-of-pocket limits. Remember, that is the maximum amount that you can be required to pay each year for covered services. Once you hit that amount, the plan pays in full for everything. They are the same limits that we saw when we talked about high deductible health plans. So roughly $6,000 for individual coverage and $12,000 for family coverage. I have a note here about the small group deductible. The book talks about a small group out-of-pocket maximum. That's a misprint. It should be deductible, and it's been repealed. So that's just a correction from the text. And then the last one, and this one is probably the one that has the biggest impact on plans, is if you are a non-grandfathered group health plan of any type, you have to provide plan participants with the right for external review. We are going to talk more about that when we talk about ERISA remedies, but basically what this does is it gives participants a way to appeal denied health plan claims that depend on medical determinations. So if you get a claim denied because the plan says what you got wasn't medically necessary, or because the plan says it was experimental in nature, anything that sort of relies on medical judgment, you can take to an independent third-party review organization that is not going to give any deference to the plan's decision. They're going to look at it de novo and make their determination. We will see when we talk about remedies that this is a huge improvement over litigating these claims from a plaintiff's perspective. So it's a big deal for plaintiffs. It's also a big deal for plans, because not to give anything away, but when we talk about litigation, we're going to see that it's really easy for a plan to deny health care claims and really hard for plaintiffs to get those denials overturned in court because of the standard of review that's used. So this one has a really big impact. And the reason I have it in italics and with an exclamation point is to emphasize what a big deal this is to plans. Many plans are trying to remain grandfathered just to avoid this requirement because they're worried about the cost implications. All right. So now, let's talk about Burwell versus Hobby Lobby. So by happy coincidence, we set this date for the campus preview day in December, I think. And by happy circumstance, we happen to be talking about one of the most notable Supreme Court cases in the last term, which directly implicates employee benefit plans, which is Burwell versus Hobby Lobby stores. This is, in a sense, very different from what we normally do in this class. We're going to talk about religious freedom, but it's a great example of the way that the law works, right? So in employee benefits, you have people who are very used to working through the weeds of a statute, and all of a sudden you have a Supreme Court decision that you have to deal with where you have to essentially become an expert on federal law as it regulates freedom of religion. Okay, so let's see. Ms. Vo, can you tell me, who are the plaintiffs in this case?
Well, Hobby Lobby, but there's also others. And then, this was Hans and Conestoga.
Right, so those are one is a family name, one's a company name. Are they bringing the lawsuit? Well, so let me back up. What type of businesses are they?
They're closely held corporations.
And are they bringing the suit as individuals or as the corporate entities? Right. So we have 3 different closely held companies that are bringing the suit. And what's the basis for bringing the suit? What are they challenging?
They're challenging the RFRA and the mandate requiring the employer's plans to provide contraceptions, but they oppose 4 of them.
Right. So this goes to our preventive services requirement that we just saw on the previous slide. So these plans are all non-grandfathered. Even though they all existed on March 23rd, 2010, they've made changes. So they've all lost their grandfathered status. So they are subject to the preventive services requirement. Part of that requirement is you cover basically the full range of contraceptive and sterilization services. They only object to 4. They say, we don't want to provide coverage for these 4. What's the nature of their objection to those 4? Why do they pick those 4?
It's mostly just because of their religious beliefs regarding abortion and that these contraceptives are not just preventative.
Right. What do they think these contraceptives can result in?
Death to fetuses.
Right. So it's not that in this case, it's not that their religious beliefs are against all forms of contraception. It's more narrow than that here. They believe that these 4 forms of contraception are actually abortifacients, right? That they can actually result in the abortion of a pregnancy. Right, 2 of these are probably pretty familiar. 2 of these are the morning after pill. 2 of them are intrauterine devices. Okay, so you mentioned that they make a claim under the Religious Freedom Restoration Act. Why don't they make just a free exercise claim here? Right, Constitution guarantees the free exercise of religion. Why isn't that a good option for them?
One thing that the court noted was that Health and Human Services had already made another system for nonprofit corporations.
Right, so we'll get to that. But do you recall why? So they don't reach the free exercise claim, but both the majority opinion and dissent talk about why it's no good to them. Someone else know why free exercise doesn't help them here? Yeah.
Yeah, because the Supreme Court in Smith, whatever it is, I think the defendant in that case, basically changed the standard for free exercise claims, and they made it so that neutral, generally applicable laws may be applied to religious practices, even if they infringe on those practices. And Congress then responded with RFRA.
Right.
So.
Yep, exactly right. So the free exercise clause, which is, probably the first thing that jumps to mind if you're talking about freedom of religion, doesn't do them any good here because existing Supreme Court precedent very clear that if it's a law of general applicability, that's enough, right? As long as you're not directly targeting a religion or religious beliefs, the law survives. So it's clear that if we were looking at this under free exercise clause, the plaintiffs are done because this is clearly a law of general applicability. So free exercise clause is no good, but Congress responded to the Supreme Court decisions about free exercise by putting in place by statute more protections for religion. So let's take a look at what RFRA, the Religious Freedom Restoration Act, provides in its text, because that's going to be how we end up evaluating this claim. Okay, so we start off with the premise that the government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. I mean, very directly trying to counter the existing Supreme Court precedent that said Rule of general applicability is okay. I have highlighted in different colors the phrases that we're going to have to work through to figure out how it applies, right? We're going to have an issue with what it means to substantially burden. We're going to have an issue defining who is a person and what it means to exercise religion. There's a little bit more that we have to get to. If the finding is that the law does substantially burden the exercise of a person's religion, the person is going to be exempt from the application of the law unless we have two factors met. First is that the burden is in furtherance of a compelling governmental interest, so we're going to have to define that and see if we satisfy it here, and that the law is the least restrictive means of furthering that compelling governmental interest. We're going to have to work our way through all of these key terms here. So Ms. Vogt, does this law seem broad or narrow in its scope? How would you characterize its general protection of religious belief?
Pretty broad.
Right. So it's sort of helpful to think about why Congress did this and what they were trying to do. They really wanted to do more to protect religious beliefs than otherwise existed. So this is a pretty broad statute. All right, so let's talk about the first big issue, person. We already talked about the fact that the plaintiffs here are not bringing the action as individuals, but they're bringing it as corporate entities, right? They're incorporated, but they are closely held, so the families control the corporations fully. Why doesn't the court just say corporations are not people? What's their basis for, how do they analyze the meaning of person?
I'm trying to find it in the text, but I think there was somewhere that said the law was just like as corporations under, or as persons under the law.
Right, so there isn't anything in RFRA that defines person. Often there is, right? Often statutes are going to have a little definition section. It's going to say people means X, Y, and Z. There's nothing in RFRA that defines person. So basic problem of statutory interpretation, we've got to figure out what person means. There are lots of different approaches to this, right? One is you would use ordinary meaning, but they actually rely on another federal statute to define it, the Dictionary Act. Had you ever heard of the Dictionary Act before reading this case?
No.
No, neither had I. I had to look up what the Dictionary Act was. When I first saw it in the reading, I thought they were just going to say we look at a dictionary, because you often see that, right? If you don't know what things mean, you use their ordinary definition, and what courts often do to figure out the ordinary definition is to look in a dictionary. But no, they cite the Dictionary Act. So this is kind of interesting. It was passed in 1871. This is the full text. So even though it's kind of small print, I put it all on the slide because it's sort of impressive. It's a federal statute that is a sentence long and can fit on a single slide. How things have changed since 1871. It actually, the reason that none of us have heard of it, I don't know. Had anyone heard of the Dictionary Act before reading this case? Okay, that makes me feel better. It doesn't do much. I mean, it says things like words importing the singular include and apply to several persons, parties, and things, right? Saying singular, it will also include plural. Plural includes the singular. Words importing the masculine gender include the feminine as well. Present tense includes future tense. And then they define just a few things, like the words insane, right? And you can tell it's 1871 when you look at the definition of how they define an insane person. But they also happen in this very short list to define person. The words person and whoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. So court uses the Dictionary Act here to say it includes persons, right? We have a federal law that still is in effect, right? It's from 1871, but it hasn't gone away. It hasn't been overruled, that says persons include corporations. So I have learned, surprisingly, lots of people were watching this case to see whether the Supreme Court was going to actually rely on the Dictionary Act here, because we saw before this case a huge difference of opinion as to the weight of the Dictionary Act. So many courts never bring it up. Obviously, there's a limited number of definitions, right? It defines insane, person, officer, signature, subscription, oath, and writing. So, maybe that's why. But even in cases dealing with these terms, federal courts differed substantially on whether to even look at the Dictionary Act or whether to just ignore it and use other principles of statutory interpretation. So one odd thing that comes out of this case is, of course, now the Dictionary Act really means something because you have a majority opinion of the Supreme Court saying we look at the Dictionary Act if it's not defined here. Sort of puts Congress on notice that if they don't like the results of the Dictionary Act, they better say something different. What would be other ways of determining a statutory term like person where it's not defined in the statute? So obviously they went with the Dictionary Act, but what are other sort of commonly used tools that we might rely on?
Supreme Court precedent. Other similar statutes.
Right. So you could look at whether the court has ruled on it before. You could look at similar types of legislation. What could you look at in RFRA? Even if it doesn't define person, is there something you could look at with respect to RFRA to try to figure it out? Yeah.
Legislative history.
Right. So often, if the statute doesn't define it, what you might do is comb through the legislative history. You might look at the committee reports and look at floor debates to see, did they ever mention that they thought corporations could be included in persons? We don't get any of that in the part of the decision that we have, right? They didn't even go to that because they took the position that person was already defined in federal law. So once you take that position, right, once you say the Dictionary Act is relevant here, we're not going to get into any of the other normal sources that we would, right? So we're not going to talk about ordinary usage, right? And of course, we all know that ordinary usage, corporations aren't people, right? How we normally use that term. We avoid that discussion entirely by going to the federal act. We also avoid looking at legislative history. If you say federal law, federal statute provides the answer, you're sort of done and can avoid all of that. Okay, so Dictionary Act tells us corporations are people. So HHS tries to, and we'll go back to the text, to say, okay, corporations are people, but corporations can't exercise religion. How does the court respond to that objection?
Well, the court said that they didn't provide a persuasive explanation for it. And exercise of religion involves not only belief, but physical acts. And as a corporation, capable of physical acts.
Right, so corporation is a legal entity, right? It's this separate legal entity from the people. How can a corporation exercise religion?
Well, one of the businesses adopted it in its mission statements.
Right? Right, one of the companies had explicitly that they intended to be a firm that operated in accordance with Christian values. And here, was there any question that the people running these companies sort of held these religious beliefs? No, right? I mean, a lot of it comes down to the fact that these were entirely closely held businesses, right? These families were the only sort of relevant owner, right? They were the controlling interest in every single one of these, for every single one of these plaintiffs. And so that helps the exercise of religion problem. I mean, HHS tries to counter the RFRA argument by saying corporations can't exercise religion. Imagine if a public company tried to exercise religion, right? How would that work? How would we determine what this entity that's held by, a million different shareholders believes from a religious perspective? And they sort of get around that problem by saying, we don't have it here, right? There's no question that this company, as it exists, holds these religious beliefs. Okay, so then we have to figure out, all right, so corporations are included in the definition of person. They can exercise religion. We have to evaluate whether the law substantially burdens their exercise of religion. Are we ever going to get into the merits of their religious beliefs? Is that going to be part of the analysis? No, right? What matters is what? So we're not going to question their religious beliefs. What are we looking for in terms of their religious beliefs? So, yeah.
Whether they're sincerely held.
Right. So how do we figure that out?
It's for the district court to figure out.
Right, we're the Supreme Court. We can just defer to the fact finder at the trial court level. Do you think they probe this at the trial court level?
No.
No. What do you think actually happens?
I think they do them at their word.
Right. Right. This is a difficult area, right? So it's clear, both majority and dissent here, they don't agree on much, but they agree on this point, that it is not the court's job to come in and say, you believe that? That's crazy, right? That's off the table. You cannot question the soundness of a religious belief. You don't get to second guess someone's religious belief. That's clear. Both sides agree on that. What matters is, as Mr. Ball said, that it's sincerely held. And frankly, as a practical matter, we defer to what people say about what they sincerely believe. So generally speaking, that is going to be taken care of for us. If your plaintiff or defendant, depending on how the litigation goes, says this is a sincerely held religious belief, we're typically going to treat that as a sincerely held religious belief, absent pretty extreme facts that undermine the sincerity of it, right? But none of that was on the table here. So, Mr. Rosenfeld, how do we figure out whether a sincerely held religious belief is substantially burdened? How does the court analyze that here?
So in this case, the court looks at the penalty that was imposed upon Hobby Lobby for noncompliance with the requirement to provide these 4 types of contraception, because if they decided not to provide them, the cost would be $1.3 million per day for Hobby Lobby, or $475 million a year. If they decided not to apply these, it's $100 per employee. So they looked at that and said it was substantially burdensome to the corporation not to offer these 4 types of birth control.
Right. So how would you generalize that into a test?
Does it cost them a lot of money?
Right. I mean, essentially, it's looking at what is the economic cost of not complying with this law, which they don't state it as a rule, but that's essentially what they do here. So the $475 million a year, right? That's a big, shocking number. that is the excise tax penalty that applies if they continue to offer a group health plan and just don't comply with the law, right? They give a lower number too, though, because the companies could just drop their health plans. If they drop their health plans, do they get to forget about this law?
So there's an argument that was raised that the penalty is less than providing health care to employees. And so this was an Amici argument, not raised at the lower court, so they didn't really consider that argument too much. But in terms of having a lower penalty amount, I don't know how that.
Right, yeah.
Well, the court also says that it's going against their religious beliefs. Part of it is they want to provide health care for their employees. It's part of their religious beliefs.
Right, so this gets kind of complicated, right? So they say, we look at substantial burden, oh, it's $475 million a year for Hobby Lobby, but they could drop coverage altogether. Now, dropping coverage altogether doesn't actually solve their problem because they still have to pay $26 million a year because they're a large employer and they would be failing to offer coverage. So still, right, $26 million a year is still a lot of money. But as you said, in sort of countering the argument, because the argument that was raised was that $26 million is sort of a red herring in terms of cost because they're saving all this money because they don't provide health insurance now. But the court essentially says that's disingenuous because there are other reasons for providing health care. In fact, not only can it be seen as part of their mission, right? So it could be consistent with their religious beliefs that they offer health insurance to their employees. They also note sort of the importance for an employer's business that even if they increase cash compensation, it wouldn't make them whole because of the tax preference for employer-provided health insurance coverage. They say you can't make that argument, right? You can't say, we can solve this problem by you just not providing health insurance for your employees. So they get rid of that. HHS makes another argument against why this isn't a substantial burden that's based on the connection between their religious beliefs and what they're being required to do. What was that argument?
So HHS says that it's too attenuated of a substantial burden because providing coverage for these types of healthcare doesn't necessarily lead to an abortion or whatever that word is that you used previously, because people might not necessarily utilize this contraceptive even though it's offered. So they said it's too far gone to say just because you offer it that the result will occur that is against your religious belief. And to counter that, the court looks at a precedent called Thomas versus Board of Review of Indiana Employment Security, where a Jehovah's Witness would roll steel that was used for weapons, but he would not work in the factory that made the weapons. The Supreme Court said if that's your belief, we're not going to get too delved into it. You can draw the line where you want to draw the line in terms of what violates your belief.
Right. That. So essentially, HHS was saying, you are, Hobby Lobby, your sincerely held religious belief is that abortion is immoral. But we're not requiring you to provide abortions. We're requiring you to pay for health insurance coverage that includes coverage for certain services that you believe are essentially abortions. But you're not making the decision, right? There's independent judgment on the part of, in these examples, the woman is going to make the decision about whether to use these or not, so you're sort of cleared of moral blame. But as you said, the court says, no, just like we're not going to judge sincerely held religious beliefs, we're not going to get in there and say, you think, well, let me ask you, so what would the connection be? How would you state their religious belief to cover health insurance coverage? So it's against their religious beliefs to
Provide health insurance that allows somebody to do something that they don't want.
Right. I mean, essentially that's what the court is saying, that their religious belief isn't just, we think it's wrong for people to have abortions. It's essentially, we believe it's wrong to participate in the financing of abortion, right? To subsidize health insurance that could end up reimbursing this service, and that we're not going to, get into the weeds and, as Alito talks about, get into these issues of moral philosophy about when are you off the hook because we have an independent judgment being exercised in this situation. If they believe it's wrong to finance abortion, we're going to let them sort of take that position and not second guess it. So essentially, we come back to that line of all we're looking at is this an honest conviction, right? Is this a sincerely held religious belief? And any dispute that this is an honest conviction or sincerely held religious belief? No, right? So we get to that point, we say, okay, we've got a person who can exercise religion, and the government, by imposing this requirement, is substantially burdening that exercise of religion. But we're not done there yet, right? So all we've done so far is to say, sort of RFRA applies to this. The law might still survive. We've got to look at the second part, right? So the law will survive if it is in furtherance of a compelling governmental interest and is the least restrictive method of achieving that. So let's start with compelling governmental interest. What does the majority say about that? Do we have a compelling governmental interest here?
So the court assumes that there's a compelling government interest in order to discuss whether or not it's the least restrictive means. So yes, in that sense, they don't rule definitively that it is a compelling government interest, but we just kind of sidestep.
Right. It's kind of interesting. They throw out some facts about why it might be, right? Here's some things to think about, but we don't actually have to decide it. So they refrain from holding that it is a compelling governmental interest. They say, we're just going to assume it. We don't have to decide whether it is, because we're going to do it in on some other grounds here, which is the least restrictive means of furthering that interest. So assuming we believe it's a compelling governmental interest to give access to these services, have they done so through the least restrictive means? What does the court tell us?
The court says no, they have not, because they could have done it in any number of other ways that the court kind of just makes up. One of them is that the government could provide this type of contraception to, I guess, all women. That's their argument. Second argument is that nonprofit corporations have an exemption. And nonprofit corporations have religiously held beliefs. And so they've allowed this exemption for nonprofit corporations for these types of contraceptions by making the insurers provide it. So if they purchase a policy, the insurance company has to pay for it, and it gets covered somehow in their cost scheme. But that way they're not directly paying for the contraception, so they can always adopt that scheme for for-profit corporations. They don't know why it's not possible for them to do so here. And the majority also does not think that this will open a floodgate of litigation.
Right. Okay, so lots of things there. Who has the burden of showing that it isn't the, I should say, who has the burden of proving that it is the least restrictive means based on what the court, how the court analyzes it? Yeah. So they essentially say the government has the burden of establishing that what they're asking through this law, so in this case, requiring employers to cover these services, they have the burden of showing that's the least restrictive means. So they have to show why there isn't something else available. As you mentioned, they say, well, the most straightforward way for the government to accomplish this goal is to just provide the services directly. We'll talk about that more when we talk about the dissent, because it's something that the dissent strongly disagrees with, for the reason that you could always potentially make that argument, right? Any law, it is less restrictive to have the government provide it directly than to have an employer, in this case, be the go-between. And probably the most damning fact here is that they already put in place a system to accommodate religious employers. say more about who are these employers that they have had this sort of separate provision for? What types of
I believe they're
corporations are they?
like they're nonprofit corporations that are like church hospitals that are providing health care. They don't want to give their employees the church hospital, although it's not exactly the church itself. It's like affiliated with a religious organization.
Exactly right. So these are nonprofits. They are still corporations, but they are clearly religiously affiliated. So we're not talking about sort of family-run businesses. You know, a common example would be something like Catholic Charities, which is a separate nonprofit but is affiliated with the Catholic Church. There are lots of examples of organizations like this, both in healthcare and in social services generally. So this is more of a practical question. Why does HHS pursue this litigation if it already has an accommodation in place? What do you suppose was motivating this litigation? Because they didn't fight it for the religious nonprofits.
I'm just guessing. I don't know. There's a cost argument here. Corporations can dump it onto insurers. It raises all the insurers' costs to provide this benefit. But I don't know why they fought this one.
Right. So that could be part of it, although, interestingly, they claim the accommodation is cost-free, right, to everyone. And part of that has to do with the cost-benefit analysis, right? These services sort of more than pay for themselves in terms of the preventive medical costs.
Nonprofits less likely to self-insure?
Really depends on the type of nonprofit. So it could be HHS was concerned about costs. You suppose there might be other people in the federal government that are interested in this holding?
Yes.
Yeah, I know, right? I'm good at asking leading questions. Right. Essentially the point that the dissent makes, right, about how once we say private corporations can hold religious beliefs, there are going to be lots of agencies within the federal government that are going, whoa, what does this mean for us, right? Does this mean we can't ever burden private corporations who may or may not have religious beliefs? But that's just an aside about how it's kind of interesting that this gets litigated because they did have this provision. They didn't fight it with the religious nonprofits. It had to be about something else here. None of us really know what the inside scoop here is, but undoubtedly there's some good explanation for it. Okay, so you mentioned that the court feels like this is not going to open the floodgates to litigation, right? What is their argument for why this is not going to prevent the application of federal law to private corporations?
It's very narrow to contraceptions, or that it's not going to apply to immunizations, it's not going to apply to blood transfusions, it's not going to apply to a whole bunch of other types of hypothetical situations that they discuss because they think it's narrow enough in their holding.
Right. So we might characterize that as a bit of a dodge, right? They say, right, slippery slope, but this is just about the facts in this case, just about closely held corporations. It's just about the contraceptive mandate. All of the rest of that is speculative, so we're not going to deal with it. All right. So majority opinion, it is a pretty straight statutory analysis, right? We've walked through how we get to these various results, but they pretty much just check off all of the important pieces of this analysis. Why does Kennedy write separately?
So in his concurrence, Kennedy agrees with the majority. He points out that religious exercise is meant to pervade in the civil, political, and economic sphere. He also points out that the government creating its own program is not necessarily a method by which to demonstrate the least restrictive method of enforcement. Sometimes that method may be very burdensome. Here was not because the nonprofit accommodations are in place. So he kind of distinguishes the least restrictive part.
Right. Right. He tries to pull back a little bit on that away from this idea that the least restrictive is always simply the government providing it itself, that, what really did HHS in here was that they already had a program in place. So clearly they thought it was okay, that there was a less restrictive method. He also said a little bit more about whether there was a compelling governmental interest here? You recall what that was?
No.
Does anyone recall, how would you characterize Kennedy on the issue of compelling governmental interest? Remember, the majority doesn't rule on that. Yeah.
He says that it's a legitimate and compelling interest in the health of female employees. So he talks about that pregnancy can contraindicate other conditions.
Right. So he's stronger on that, right? He's actually, part of why he's writing separately is to get that on the record, right? That he's not just going to say, we're assuming it's compelling. He's going on the record and saying, it is compelling, right? That there are legitimate reasons why the government would want to provide these services for women. All right. So let's talk about the dissent a little bit. And I don't know if my students caught this at the beginning of class. They thought this class ended at 2:15, so we're going to take a break in 5 minutes and let them go off to their next panel, and then we're going to continue going for the rest of class time. I know. Too bad. You could go to the faculty panel and see what they talk about there. All right, let's talk a little bit about the dissent. Why is the dissent so upset about this? I mean, what's their primary objection to this opinion?
Well, all the women on the court and one guy dissented because they believe that this decision allows corporations, sole proprietorships, and partnerships to opt out of any law that they judge incompatible with their religious beliefs. It says it subjects employees to the religious, it says employees must adhere unreservedly to the religious tenets of their employers. So now they're kind of getting imposed upon by their employer in this situation.
Right. So very much focused on the functional result and the slippery slope, right? Sort of both of those things. I think as a practical matter, we now have a majority opinion that says, the least restrictive means is to have the government provide it. So now every single business entity of any type can say that's against my sincerely held religious beliefs and essentially freely opt out of any law. So just a couple of other things about the dissent. Do they question the religious beliefs in this case?
No.
No, right? That's important to get on the table here. This isn't about saying, we think your religious beliefs are wrong, we don't agree with them, we don't believe they're sincerely held. They defer to, in this case, the corporations, just like the majority opinion does, for the reasons that we talked about. Courts don't want to be in the business of second-guessing what someone's religious beliefs are and whether they are warranted. How do they reach a different result under the statutes? They sort of have this broad theoretical objection to the holding for its functional result, but they also have to somehow make a claim that the majority opinion is wrong on the statute. How would they do that? How would they differ?
They have a lot of arguments. They attack the substantially burdened analysis by saying, as you discussed, it's a little bit too attenuated. There is an intervening player here. The woman gets to choose which health care she wants. And so it's not exactly, providing coverage isn't exactly going to lead to the result that they're trying to avoid. So it's kind of like they interrupted the substantial burden because of the woman's autonomous choice. And then secondly, they also attacked the least restrictive means analysis because the Affordable Care Act did do this by requiring employers to provide contraception. We have an employer-based health insurance system largely for a lot of people in the private sector or people below the age of 65. So a lot of people got together, experts and such, and this is the system that they created. So she thinks that that system should be preserved. So it is the least restrictive means.
Right. So in terms of substantially burden, just note that essentially what the dissent is trying to do is narrow the definition of what counts as a religious belief. So they're not questioning that these corporations believe that abortion is contrary to their religious position. They're not questioning that, but they're saying that's your belief, right? Your belief is that using these services is immoral. Providing health insurance for that is not part of your, objecting to health insurance for that is not part of your religious belief, right? This idea that they are two separate, but it has to do with how you define the religious belief and sort of how you carve that out. So keep in mind that even though we have a lot of deference to religious belief in the courts, we can still get to different results based on what we think the scope of that religious belief is and how much we're willing to sort of say, okay, I believe you on abortion generally, but I don't believe you on the finance mechanism for abortion. And same thing, as you said, with least restrictive, they disagree, saying, you know, if the analysis really is the government can always do it directly, that's going to do in every federal law, and it doesn't take into account sort of the broader structure of how we've chosen to do things. All right. Admitted students, I'm going to let you go. Thank you for joining us, and enjoy the rest of your day. And poor employee benefit students who have to stay, we will start talking again in just a few minutes.
Sure.
We appreciate it.
Thanks to Professor Monahan. Let's give her a round of applause. And thanks, current students, for letting us in your class. So let's follow the ambassadors back to Wiley 125.
Unfortunately, I was admitted a year earlier.
If those facts were on the
They had fancy stuff. It was like great. These aren't reasons.
I'm not sure.
Although I do feel like either way they have no other options or it was pretty great.
The other thing, my other question was the least restrictive buildings.
Like, yeah.
I think I remember hearing somewhere unless there are if there are none available, government parties were at least suggesting.
Because we're the only school that was honest about what the practice of law is actually.
Something this is like or this point it's not me.
That's fantastic. You can each get one. There's many left. That's kind of rude.
We got these papers, and they got candy.
That's sort of poor form.
The admitted student? Yes, they're pretty admitted students.
That's right. And honestly, there are very full ones still in the back of the classroom.
And I'm pretty sure we paid for this already.
You did, yes. Yeah. I better get a dish of candy.
I don't understand, if we understand what the majority is saying, substantially burden a person's exercise of religion is the companies having to pay the insurance that facilitated their ability to get these medications. I then did not understand at all how they can suggest that the government providing it is an alternative that's separate because
You
they
pay tax,
for the
yeah.
government.
Right, and it's just because case law distinguishes, like the case law is clear that taxing to
Right.
pay for anything is okay.
So, and
Under
how,
religious analysis.
yeah, that Sebelius case,
Yeah.
like independent businesses versus
Yeah.
So if in this situation they had said, or if Congress passed a law that said, we're passing a tax to mandate coverage that also, that happens to include abortifacients, then nobody can challenge that.
Right.
Right.
Why can't you have through Congress?
Right.
Right.
I understand the political route, and that's the whole reason the nonprofit exception is there. It's for political reasons, to get it to go through to pass it in the first place.
Right.
So I get that, but substantively, this is stupid.
Well, that's what taxes always get special treatment, just like subsidies always get special treatment. That doesn't violate the Commerce Clause, even though in fact it's the same damn thing.
Right, right. I know, it's like, we can't do it this way, but if we,
Call it a subsidy
Yeah.
and we're happy.
right. And, you know, we didn't talk about this, but, you know, the accommodation here of having the insurers separately pay for the coverage, who do we think actually bears the economic cost of that, right? I mean, it just gets passed through to Hobby Lobby and others, right? You're not going to itemize it on a bill, but there's no way the insurance company's like, yeah, we'll eat that cost. And so,
I think they might, because they are protected by ERISA and the huge lawsuits against them. That, you know, I feel like it's like something they want. I don't know.
Yeah, but it's not gonna come out of the profits.
Yeah.
They're gonna charge
Right.
more for other products.
right, exactly. So it's all about it's sort of a shell game, right? We're just sort of moving things around here.
These four contraceptives are one shots, right?
Or what?
They're not like months.
Oh, right, right.
You don't keep like paying for pills.
Right.
I mean, I think they'll have to find details like that.
And the cost-benefit, you know, analysis does in fact work out because, of course, paying for contraception is so much cheaper than paying for pregnancy. But there's a pretty long time horizon, right? Anyway. All right. Of course.
Do insurers think about the fact that they are insulated from, like, punitive damages if they're providing group health insurance through these plans? Don't they have an incentive to deal with employers?
So they certainly do, but frankly, they don't face a lot of liability even in the individual market. You know, slightly different standards apply, but at most, you sort of get contractual damages, which is paying for the service that was denied. So they don't really have a big liability fear in health
Well,
insurance
even from California,
generally.
It seems like it's a bigger issue there because they do allow, there are bad faith claims.
Right, so it'll depend on state insurance law in terms of how much liability you face. But in states like that, absolutely, you'd much rather be in the group market than the individual market. It's part of the reason why group coverage is so much cheaper than individual insurance coverage. I don't think we've talked about this, but you know, when you look at overhead in the insurance markets, large group coverage has nice, small overhead. It's a pretty tight market. Individual health insurance, the overhead is like 30 to 40% of premiums. It's huge, and part of that is increased liability cost. Yeah.
So I haven't taken corporations, but corporate law is mainly state
Yep.
statute, right? So why couldn't the state just say, amend its corporate law so that instead of being a true incorporated person, when you create a corporation, you just say, okay, this is a person without religious rights? I mean, could you just kind of limit what sort of person a corporation is?
So I think at the state law level, it would still risk preemption from the federal government. So even if you had the state say, by the way, when we say corporation, we mean a legal entity that has zero rights, right? Other than those specifically enumerated for corporations. But you'd still have a problem under RFRA because federal law still says persons include corporations. So it's hard for the state to solve this problem. Easy for Congress to solve, of course, if it doesn't like the result. Hard for states too. All right, yeah.
I just had one, can we go back to the Dictionary Act?
Of course, yes. Oh, wait, wrong way.
Okay.
I know.
So I guess I'm looking at the phrasing, unless the context indicates otherwise.
Yeah.
Did HHS try and do anything with that? To say, obviously, religion is something that an individual human being practices? I mean, I don't know if they would have gotten anywhere with it, but I would have definitely at least tried.
Right. And it's been a while since I've read the briefs, but I think they pretty strongly said it's pretty clear that in this context, based on legislative history and the like, that person wasn't used in the broader sense. It was used in the individual sense. I can't remember whether they made that specific argument about unless the context indicates otherwise. But what I think really did them in on the person is that they exempted the religious nonprofits. Because if RFRA is an issue for religious nonprofits, it's only because HHS considers them persons for purposes of RFRA. So that's a really damning fact for HHS. Really, the majority talks about it a little bit when they say there's no definition of person that includes actual people and nonprofit corporations, but not other corporations. And that's a really bad fact for them. Because there certainly is room to argue why person wouldn't include corporations here. Yeah.
Could somebody following this decision, this type of analysis, try and leverage this to pierce the corporate veil more often than otherwise? If these owners can say that their religious beliefs permeate this for-profit, closely held corporation, I would just sue them in tort, and if I were a creditor, I would come after their personal assets too, and just be like, you have no corporate shield because you've acknowledged that your personal everything. Because
Right.
to me, this defied the entire purpose of forming a for-profit corporation or a corporation in general.
Right.
Is to have a distinct legal entity, but then they're saying, but it's our religious beliefs that make it.
Right. So I'm not well versed enough in the current piercing the veil jurisprudence to really answer that question, but my gut is it probably wouldn't work because it's not that the court here said corporations are people. Essentially, they said the corporation as an entity can have religious beliefs, right? So I think there's a way to frame it that would still protect this notion of the corporate entity as separate. That's okay. This is a case people have strong feelings about.
Right. I need my contraception.
All right, it's Friday afternoon. We have all of the admitted students gone, so we're going to start talking about boring statutory provisions now. Yes, go ahead.
Since it's not vice versa, basically you can't include the feminine and then have it include the masculine, right?
Apparently there are probably reasons why we just want to refer to women separately. But you're absolutely right. That is how I would read that as well, because we don't have feminine includes the masculine. And it's probably because in 1871 they really thought there were good reasons why we would have laws that just applied to women. It's a rich statute. Yeah.
Why doesn't Congress put a time, what do you do about acts like this?
Right.
You
I mean,
refer to them in very major cases 150 years later.
That's right.
It was passed, it's a good law, it's good forever.
Right.
So what?
I mean-
I criticize it too, but should it, to give the act fairness, should it be criticized? It's an act.
Right. Right? It hasn't been repealed. It's out there. I think my take on it is it's a great example of the challenges of lawyering. Right? How do you ever catch something like that? You catch it when the other side briefs it. And the other side briefs it because they had some associate who did a Westlaw search for the definition of person and went to the partner and said, there's some act from 1871 that says person is corporation. And they think this is brilliant, and they, get a court to agree with them. But it's sort of the way that litigation proceeds. You're looking for these nuggets, and they found one here. If we had a functioning Congress this would be, and I say that, this is a neutral statement with respect to ideology. They don't pass anything. And so if you
If
had.
they did agree, they can just go pass a new definition of person.
Absolutely.
For the act.
Or say, we're going to throw out the Dictionary Act, right? There's lots of things that Congress could do, but they simply, no one can pass anything right now. Normally what you would see after litigation like this, where they say, oh my gosh, there's what? There's this law that says what? You would, in years past, you would have seen action to address it one way or the other. But that just doesn't happen now. Judah?
Oh, yeah, I was just going to comment and say that they could have just, they could have just exempted the ACA from RIFRA. Very easy.
Right.
So, I just thought it was interesting. I noticed that the book says that the Dictionary Act is 1 USC 1. It's the first page of the
Oh.
United States Code. So you'd think it'd be more commonly known than it is.
Right. What is at the beginning? Oh, the Dictionary Act. Honestly, before I looked it up, I thought it was going to say, when words aren't known, you should look in the dictionary. That's actually what I thought it was going to say. Okay, you're trying valiantly to avoid the boring statute, but it's not going to work.
You showed us that brief. Ooh, this is interesting. Oh, no. Just kidding.
Public benefit corporations, there's a lecture about it yesterday. You can
Yes.
have like a corporate purpose besides making profits as long as it betters the world. So if your corporate purpose was to be religious, then maybe a non-closely held corporation.
Oh, yeah.
Itself in the form of act, because it can point to the fact that its corporate document makes it religious.
Right. And, that's good. Good job. But you still have 20 minutes to eat your candy. Does everyone have a dish? They're going to come in and get them soon, Yeah. All right. We're going to talk about the employer mandate. We're going to talk about how to count employees now. I know it's kind of a letdown at this point. All right. So the ACA imposes all sorts of substantive requirements on group health plans, which we've talked about how interesting that can get. I will say, related to public benefit corporations, I do think there's room for publicly traded corporations to hold religious beliefs. I do. They nicely skirt that issue, but I absolutely think that could be. And the other thing I will mention, I want to delay too, but the other thing I'll mention is how hard this issue is in practice, right? So if you're an employee benefits lawyer and you get this case and you've got a client that comes to you and says, I don't want to cover the following things for my sincerely held religious beliefs, all I'll say about it is this is a hard case to counsel clients with respect to in terms of, especially if you're like a publicly traded corporation, who decides what their religious beliefs are? The officers? The shareholders? Would you put it to a vote? Because there are plenty of public corporations that have officers who hold very strong religious beliefs. Yeah.
And then how do you challenge sincerely held?
Right.
Do you need to find a majority, or do you need to find one person that disagrees?
Right. Right. And I think it's the dissent. One of the decisions, brings up, like, what are you going to put a proxy vote? Like, we're going to put it to the shareholders? Do you sincerely believe that X is the case?
Well, could you just amend your mission statement to include, we, the target corporation, shall pursue making money in accordance with Christian values?
Right. 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 We don't know. That might be enough. Yeah.
Could you have that part of the contract to say that all the decisions I make
Are going to reflect this religious view.
That's why it's such a slippery slope.
Right.
We're talking about target every bill, all the shares we receive.
There's one.
They take one share that propose it. That's it.
Right. But and where would it come from? You see activist investors on various issues. Why couldn't you see activist investors on this? Now, they tend to be very, bottom line driven, but we could come up with some healthcare services that hurt the bottom line. yes, I don't envy the lawyers that are having to have this conversation with clients about what are the boundaries and how would you go about trying to establish it. Yep.
When we were talking about definition of person a little bit, there's the language preceding that on page 410, where they're kind of, I mean, I don't really know how it applies. It's kind of prefacing everything they're about to say. And they're talking about how the corporate law principle is the established body of law specifies the rights and obligations for the people. So is that basically just going to the exercise of religion, or can that be applied at all to their understanding of the person? Or is there finding for corporations being persons really just supported by the dictionary?
I mean, I think that if you're going to rely on this case for precedent, you would have to, the authority they provide really is the Dictionary Act, but they do throw in some other things about, well, we use person all the time to mean both natural people and artificial people. But I guess if I was using the case as precedent, I would say it's limited to the Dictionary Act is your next stop in terms of defining person. All right, you're out of luck. Here we go. We're going to learn how to count employees. That's what we're going to do. Okay, so we're going to regulate what these plans have to look like. We're also going to penalize employers that don't offer plans or that offer plans that fall below minimum standards, which we'll talk about. This is what we refer to as the employer mandate. It only applies to what we call large employers. As the book points out, we use large employer in many, many different ways. For this particular purpose, it means you have 50 or more full-time equivalent employees. So that's why I say we're going to learn how to count employees for this purpose. Before we do that, just note this is one of the many things that we have delayed in ACA implementation. So right now, so for 2015, the employer mandate exists for employers with 100 or more full-time equivalent employees. It is scheduled to become effective for the rest of the employer group next year. But of course, as with anything that you see them pushing out, it's sort of stay tuned. The plan is next year. That could change. All right, so now let's talk about counting. We know that when we're counting employees, we are going to look at how many employees you had over the prior year, not the current year. That is done for administrative ease, because they actually exist and you can count them rather than trying to adjust as the year goes on. You include, first, what I call actual full-time employees. For purposes of this requirement, you are full-time if you work 30 hours or more per week. So just note that that, of course, is less than the standard 40 hours that you usually see for full-time employment, or 37 and a half hours, which you normally see. It's 30. It's a lower bar. It doesn't matter what they're actually scheduled to work. You're actually going to look at their hours or some hours equivalent, right? So labels don't matter. You're going back through the prior year and seeing, on average, did this person work 30 or more hours? If they are a full-time employee for purposes of counting. Yeah?
Which average, like mean, median, or mode, or does it matter?
I'm trying to think if it would matter, but just mean, I think, is what is used.
Because that could be like.
That's true. It could be different. Yeah, I believe it is mean. Then we have to figure out full-time equivalents. And basically what you do is you add up everyone who's not in that first category, right? So you look at last year's records, you figure out who's in that first group, who worked on average 30 or more hours. You've dealt with them. Take them out of the records now. Everyone that is left, you're going to add up the hours that they worked, and you're going to do it on a monthly basis. You're going to divide it by 120. That's getting to the 30 hours a week standard. So let's go through an example of what we're talking about. I'm simplifying things here. I will not make the complications more complicated than this level, okay? Because there's an insane amount of nuance and detail in terms of how these calculations go. This is the level at which I want you to be comfortable with this. So let's say an employer has 40 employees who work, on average, 30 or more hours per week. Okay, so they have 40 full-time employees. But then they also have a bunch more who work part-time. So they have 100 employees who each work 15 hours a week. You can probably just eyeball this, right? If we think that full-time is 30 hours, you have 100 people who work 15, probably eyeball that we're going to end up with 50 full-time equivalents. But just to go through how it works, so we have 40 actual full-time employees. We take everyone else, and we are multiplying here the number of employees times the hours per week. And then I had to multiply it by 4 because the statute says we look on a monthly basis. So all I'm doing there is taking their weekly hours, multiplying by 4, over 120 gives us 50 full-time equivalents. This employer has a total of 90 full-time equivalent employees. So they would clearly be subject to the mandate. Are we good on this piece? Because it's per month, so because I had given the hours in weeks, I had to convert it to months for purposes of the calculation.
I feel like this has been misrepresented in the press.
In what sense?
Like, I feel like I've heard all these news stories about how an employer would just cut people's work hours down to 28 hours and then to be compliant. And there was like this huge fear, but it's like that wouldn't get them out of anything.
So, we will talk about this. What we've just gone through is just to see if the mandate applies. What you're talking about comes into play with the penalty. There is a benefit to cutting hours for the penalty. But was there another?
I was just.
Go ahead.
Ask if we, in cases like this, just multiply by 4 instead of, let's say, 4 by 3.
Yes, always use 4 for our purposes, even though it's not entirely accurate. Yeah.
And where are they? So they're determining the hours per week based on like the whole year.
You would actually count actual hours throughout the whole year.
And then they would determine how many hours per week and figure that out.
So as a technical matter, you're looking at whether the employer has averages 50 or more full-time employees per month.
Yeah.
So it's actually even worse than this. I'm trying to skip that stage of calculating, January through December and averaging, but that's actually what it does, which is why there's anything to do with a month. But it really is, you look at the situation throughout the entire year. All right, now let's talk about penalty side of it. So we've just talked about who's subject to the mandate, who potentially faces a penalty of that group. First one is easy. An employer who has 50 or more full-time equivalent employees and doesn't offer a group plan at all, right? They just aren't in the health insurance business. And at least one of their employees goes to the exchange and gets a premium tax credit. We're going to hold off on talking about who gets a premium tax credit for just a minute, but that's the trigger, first trigger. One thing to note at this point, premium tax credit is only available for individuals who have household income between 100% and 400% of the federal poverty limit. So if all of your employees are above that threshold, even if you're a large employer and you don't offer any health insurance coverage, you wouldn't actually owe a penalty because none of your employees could go get a premium tax credit. So especially for some employers in large cities where salaries tend to be pretty high, so if you look at a lot of New York City employers, for example, they wouldn't have people who are below 400% of federal poverty. They'd be okay. Second is a little bit trickier. Even if an employer offers a group health plan, it can still be liable for a penalty if the plan they offer is either not affordable or fails to provide minimum value, and at least one person goes to the exchange and gets a premium tax credit. Affordable is we look at the percentage of income that the employee has to pay for employee-only coverage. If it's more than 9.5% of their income, it's considered unaffordable. So one way to think about this is if the employer wants to make sure they don't have liability here, they've got to keep premium levels below 9.5% of their lowest paid employee, or vary premiums for every person, but employers don't typically like to do that. Minimum value has to do with how generous the plan is. The standard is an actuarial value of 60%. What that means for our purposes is that the plan, on average, pays 60% of covered expenses. So if you go to the hospital and you get a bill for $1,000, the plan pays $600 of it, and you pay $400. It's more complicated than that, but that's the basic idea. They're trying to get a sense of how generous the plan is and to make sure they at least are going to pay 60% of the costs that you incur. Let's start talking about the penalties. So we have two triggers, remember, no group health plan at all, or a group health plan that fails to meet minimum standards. We have different penalties depending on what trigger you have. So, trigger number one, you just don't offer a group health plan at all, and you have an employee who goes and gets a premium tax credit. That's going to trigger a penalty. This is where our actual full-time employees come in, because the penalty is determined based only on the number of actual full-time employees, meaning people who actually work 30 or more hours per week. Just to make things nice and complicated, we arbitrarily subtract 30 from that number. So sort of the first 30 don't count, don't ask me why, and multiplied by 2,000. So in the example that we just went over where there were 40 actual full-time employees and 50 full-time equivalents, right? We said they're subject to the mandate. If that employer didn't offer a plan at all, this is how their penalty calculation would work. 40 actual full-time employees, not the 100 number, right? Or 90 number, excuse me. Less 30, that's just our random subtraction. So that's 10. Multiplied by 2,000, they're going to pay $20,000 a year if they fail to offer a group health plan. So the point about doesn't this incent people to make everyone work at 28 hours per week? If you weren't going to offer a group health plan, that would be a good strategy. Let's say you did that. You pushed everyone in your company to 28 hours per week. You might be subject to the mandate. But when we came to do the penalty calculation, you don't have any actual full-time employees. You don't owe anything. So there are, we'll just say, labor market distortions that result from this structure.
So the only people who would do that would be people who don't want to provide coverage.
Right. Which isn't going to be a lot of large employers. It would tend to be large employers who have low-skilled workforces who don't have a lot of bargaining power is typically where we'd see it. All right, I'm going to try to squeeze this one in too. The penalty for the second trigger. That's where you offer a group health plan, but it's not affordable or it doesn't offer minimum value. The penalty is the number of people, the number of actual full-time employees who go to the exchange and get a credit multiplied by $3,000. But in no event will the penalty be more than it would have been if you just didn't offer a plan at all. And that makes sense, right? We wouldn't want to penalize people who offered a crummy plan more than employers that just offered no plan at all. So in our example, we'd need to know how many employees went to the exchange and got a premium tax credit to figure out the penalty. So I've just assumed 5, just made that number up. So assuming 5 actual full-time employees went and got a tax credit, penalty would be 5 multiplied by 3,000, 15,000. That's less than the 20,000 we calculated in the first situation, so 15 would be their penalty. Again, there might not be any penalty if no full-time employees get a tax credit. And even if 10 got a tax credit, they would still be capped at $20,000, right? Because the penalty will never be larger than the one we calculate in situation number 1.
So you do the calculation assuming they did not offer a plan to figure out what the number would be?
Right.
Is that completely
And that's,
hypothetical?
right, exactly. That's just sort of your cap. But you sort of always have to do the calculation from the previous slide for situation number 1. All right, that's it. Have a good weekend. I'm still going to have you go ahead and do the reading for next week. I'm slightly optimistic that we'll catch up next week, maybe. And don't forget to empty the candy dishes on your way out.
They do have stuff back in this room, so actually. Yeah.
Oh, see? We've got an ambassador in the room who is preventing us from stealing the candy. I'm sorry.
Just throw your wrapper away.
Just letting your Professor Monahan's thoughts.
That's right.
So did they contact you, Professor Monahan, about teaching this class today, or was that, were you just assigned?
So, honestly, I don't think there are any other choices.
Is that right? No, I think you're.
There might be, I don't know. But generally,
Yeah, try and help you out.
I didn't think anyone taught on Friday afternoon unless they have to. But anyway, so I don't think there are any choices. But yes, I just got an email from them saying. But really, the way the Hobby Lobby timing worked out. Yeah. Although, I still remember going to, like observe classes when I was a prospective law student.
Yeah.
And I never had any clue what was going on.
Yeah. I'm sure that half of them were zoned out.
We should plan to take you.
Yeah, we should have scripted it. Absolutely.
This is now many years ago when I did it. All classes were straight out of paper chase. They were totally intense, and your students had to stand up when they were all on. They'd be like, Miss Fitzpatrick. You got to stand. That's crazy. Yeah, not really a good selling point for law school. I did still go, but I will say that the worst school that I went to was like, I'm going to cross that off the list. This is the guy that they show you. No thanks.
Hi, so, in the Hobby Lobby case, maybe it's just the edited version that we had, but I had a version of it for my common class as well.
Cool.
Why wasn't, Citizens United included at all? Because it seems like that opens the door for corporations or people, and they have
Right.
rights and beliefs. And
Right.
That was, why was that raised? Am I just misunderstanding the applicability of it?
So, and I've read Citizens United, but I'm supposed to do
Somebody
something.
can't just say foreign land. I mean, it's for campaign funds. Who cares? Which is a problem, because we should care. Because now we have a nightmare situation.
But I wondered the same thing, and I'm sure it has to do with how they interpreted person under Citizens United. I just don't know the decision long enough to know. Was there something specific in Citizens United that would make it inapplicable here? Or there's also a sort of political explanation of just Citizens United was so divisive. Maybe you don't want to say,
Rehash that
see,
again.
we love Citizens United.
Yeah, we'll bring up the decision that no one likes that we did. Yeah.
is. So in con law, did you just talk about it in terms of, I suppose it was probably pretty similar, right? Just an application of RFRA?
Yeah, we did not go into it too much.
Just for all the evidence that we